list for hearing on 3rd of February
My lord.
2026.
My lord, the attachment order has been stayed, my lord. That
Interim order passed earlier to continue till the next date of listing.
I'm deeply obliged.
It would silence. Please, who you will collect from the registry, please. Otherwise, it will be difficult
My lord.
for you to be traced out.
My lord.
না একটু রেজিস্ট্রি দিব আমি হ্যাঁ ওটাকে না ফোন টু কিন্তু আমি ফটোকপি করবো না
Item 15 of the list.
wait please.
As per the last order, the LCR has been received by this court. The LCR was called to see whether any document was placed by the engaged counsel in the first appeal, empowering him to appear on behalf of his client. However, I've gone through the LCR, no such document is there.
Yes, what do you say?
Lordship, my case is dear Lordship. The matter was Lordship while it was a placed before the local Lordship. Lordship, perhaps he was not present there, Lordship. His client Lordship. But the counsel Lordship, he always Lordship contacted with the party Lordship, that means with the legal officer, over telephone Lordship. Very times Lordship. Even WhatsApp messages are there Lordship. Thereafter Lordship, even they call with me Lordship, with my party also Lordship, over telephone. Then Lordship matter was settled Lordship. We Lordship argued about the amount of settlement Lordship. They fixed the amount, they consider Lordship. Now perhaps Lordship, now they are turn of their face Lordship. Now saying
Loka Adalat isn't the requirement, the presence of the council is more important than the presence of the party.
Presence of the
party
party.
Lordship, that council, so Lordship, he is outside. So we can proceed our settlement, then he will come Lordship. And in this way Lordship, we stated Lordship. That's why Lordship.
No, was it signed by the party?
No, our side we have signed Lordship.
No, the other party. How can it be a Loka Adalat?
We have not
Yes,
signed.
Lordship.
What is the difference between a court and a Loka Adalat? Loka Adalat, presence of the council is not at all mandatory, but presence of the party is mandatory.
But his message Lordship is shown before
No,
the local.
Those are, see, nowadays the strict requirement has been diluted. Even we are conducting Loka Adalat where we have do video conferencing. But here, it is not an individual, it is an organization who is before us. Now, organization has to be represented by the authorized representative in the proceeding. Had it been a case, council has said something, orders passed, matter would have been different. Now, whether a council and an advocate.
So, Lordship, that thing, Lordship, still I am not confirmed, Lordship, whether the council actually have the power or not, I don't know, Lordship.
No,
Because
council cannot have.
Cannot.
Council is a council, he is not a part of the organization. He gets power from the Wakalatnama. After the case is determined, Wakalatnama, after the case is over, Wakalatnama gets determined, matter over. Unlike an employee or an officer of the concern.
Yes, Lordship, but while he showed the message.
No, you are correct.
While
You are correct. At that time,
but stay in the mobile, Lordship, I cannot say, Lordship, but
what is your name?
I'm a Ashok, Lordship.
Mr. Hawk. See, you may be correct in your understanding.
Yes, Lordship.
Because the endeavor in a Loka Adalat is to settle dispute.
Yes.
The counsel for the other side came, he had shown the WhatsApp messages that he is authorized.
Yes, Lordship.
All on facts may be correct, but on law, the requirement of law, that settlement has to be reached between the parties in their presence.
Others, Lordship, on affidavit, Lordship, on miscase, Lordship, they filed their Lordship. They admitted this, we have settled the matter, Lordship. That may be kindly lead to the Lordship.
No,
Yes, Lordship.
that can be taken by the consumer forum in its on its own merits and pass orders.
No. That petition filed by the said person, Lordship. Said person, they himself filed.
Understood, but it cannot be taken in a Loka Adalat. Loka Adalat is whatever is there in the pleadings or not.
Consumer forum, Lordship, not before the local. It was filed before the consumer forum, Lordship. It's a consumer forum.
Mr. Hawk, that is what we are trying to put to you. This challenge is against an order passed in the Loka Adalat. Now, Lok Adalat functioning is different. You say that in the consumer forum, an affidavit has been filed admitting the liability or whatever is there. The forum can pass appropriate orders.
They already said that this is already settled, so now it is barred by res judicata. Now at this point is already their lordship. There is two orders passed before the consumer forum.
Let the
lordship.
consumer forum decide in
And
accordance with law.
that two orders lordship has the challenge lordship. So two competent orders is still existing lordship. They have not challenged that lordship. Now they are overtaking that two orders lordship. Now they have come to before the court lordship, the High Court lordship. So that two orders only this type of order.
See,
lordship.
those two orders are not before us.
Yes, lordship. Yes, also.
We are only required to answer the question which is raised by him, the petitioner before us, saying that the settlement in the Lok Adalat was done in absence of our authorized representative and was signed by our council. Whether it can bind,
They said,
if you can show any provision in the act that
Act also lordship, it is silent lordship, whether the sign of parties are recorded or there is silent lordship. Only
No, no.
the compromise will be done by the parties. Yes,
Parties.
yes, only parties. That is their lordship.
party.
Otherwise, that is not. And lordship, now see lordship, my body lordship, my vehicle was snatched in the year 2015 lordship. See that I am
Okay,
fighting
one
lordship.
on
Amount is a very,
irrespective of the merits, what is your why have you altered your stand?
very simple amount
We have
lordship.
not altered our stand, your lordship. The thing is
And why
that
don't you compromise? Why don't you settle the matter?
a settlement cannot be made because we have not seized his vehicle. His claim is that we have repossessed his vehicle, but from our side, we have stated that we have not repossessed his vehicle.
Where is the vehicle?
The vehicle is with him
No,
because we have not
vehicle is not
repossessed
visible.
it.
Lordship, they taken the vehicle and they sold it lordship without giving any information lordship. Thereafter lordship remaining balance I have paid them lordship. Then also they have not given any information lordship. I filed a case before the
Vehicle is not with you.
no lordship. Before the police station. lordship.
Vehicle is also not with
Police
us. We have not-
police seized the vehicle and is still
It
like
is-
with the police station
It
lordship.
is in his case, he has stated that although he has stated that vehicle has been repossessed by us, he has again stated that the vehicle was seized by the police from some road.
When lordship they given no any information
we have
to me.
repossessed
Then lordship I
Let
filed
us see the records because the last
I filed the
occasion,
FIR. Then police seized lordship.
last occasion the court has made an observation that the learned council was authorized to even take appropriate action, steps in the Lok Adalat.
On a last, lordship, as per para number 4, documents was called for whether to see whether any authorization is there. I've gone through the records, lordship, there is no authorization.
And the deeply
And when was the Lok Adalat?
Lok Adalat order was
When was it? Date?
on 49 lordship because
14/9/24.
14/9/24.
yes lordship.
In that order, the representative signature is not there. And in order 26/9/24, your lordship.
Just a minute, please. There is no authorization here.
No authorized.
So
The court wanted to, that is the purpose. Then if there is no authorization, see what was the order of this court on 11/12? In the opinion of this court, taking into account the judgment of the Supreme Court in Prasanta Kumar Sahu, the said cannot be the issue. What can be the issue at best is to whether the counsel who appeared on the behalf of the petitioner before the local adult and signed the compromise were authorized in writing to do so by the petitioner, and that authority was placed before the local adult permitting the said counsel to sign. For that purpose, it is the opinion of the court that the records will be necessary. Accordingly, records are called for. We have seen the records. There is no authority.
maybe lordship. That is because I have not seen that he has submitted any document, lordship. That is from the message, lordship. Otherwise, I cannot say.
We cannot go by that.
Lordship, can it be, lordship, that he also, lordship, file a complaint for the bar council, lordship. Lordship, can I please whether that what report, lordship, or what answer he has given that
No, no,
council
that-
before the bar council, lordship?
That is not nothing to do. That's a different cause of action. That's a
Lordship,
different cause of action.
The plea has taken, lordship, the company has taken the plea, lordship, immediately, lordship. When the lordship matter was settled before the Goalpara local lordship district forum, lordship, then also they taken plea that advocate council, their advocate lordship
So,
committed
Mr.
wrong.
Hawk, Mr. Hawk,
So, lordship, this is
Mr. Hawk,
immediately-
these matters which you are raising
Yes.
may be all relevant, but it cannot be relevant for adjudication of the issue
Yes,
before
yes.
us. We are only to decide whether agreement could have been arrived, settlement could have been arrived at in a local adalat
Yes, Lord.
in absence of the party.
Yes, lordship, that is the issue. legal issue,
And
lordship.
advocate has said he was authorized, but there is no authority letter. And there will be no difference between a local adalat and a ordinary proceedings, court proceeding. We can allow this. No point fixing, having this. The matter will be decided on its merits by the Learned Forum.
Yes.
Yes, lordship.
No
yes.
answer, please.
What is your name?
JK Bhuya.
Heard 3 J.K. Bhuya, Learned Counsel for the petitioner. Also heard 3 S. Hawk, Learned Counsel for the respondent number 1.
Yes, lordship.
Considering the issue involved, comma, the presence of the respondent number 2 for adjudication of this proceeding may not be necessary. Full stop. Para? Oh, no, exactly. This court has also noted that pursuant to earlier orders passed by this court, the records of the learned Assam State Consumer Disputes Redressal Commission have been requisitioned and placed before this court. Para, please have your seat. The short question which has arisen for determination is whether a settlement can be arrived at in a Lok Adalat in the absence of a party and only with the presence of the learned counsel for the said party. Full stop. Para. As per the facts projected, comma, the learned commission was seized with an appeal against an ex parte order passed by the Learned District Consumer Forum, Walpara, in CP case number 02 of 2017, whereby the present petitioners were directed to pay certain amount to the respondent number 1. Full stop. The said appeal was numbered as FA number 76 of 2018. Full stop. The appeal was a part of the National Lok Adalat held on 14/9/2024. Full stop. It is the specific case of the petitioners that though a purported settlement was arrived at in the said Lok Adalat held on 14/9/2024, the petitioners were not represented by their authorized officer, and the counsel of the petitioners had made certain concession without any authority. Full stop. Para. It is the aforesaid order which has been put to challenge in this petition filed under Article 226 of the Constitution of India. Full stop. At the outset, comma, it may be noted that orders passed in a Lok Adalat are not liable to be challenged in any further proceedings, as it is final in nature, which however would not oust the jurisdiction of this court exercising powers under Article 226 of the Constitution of India. In this regard, one may gainfully refer to the case of so and so, wherein the following observations have been made. Para. I have heard Sri Bhuya, the learned counsel for the petitioners, has submitted that the settlement arrived on 14/9/2024 in the National Lok Adalat cannot be deemed to be a settlement under the, where is the act? Act. Some legal service, legal service asset under the so-and-so act, which envisages that settlement has to be done between the parties. Full stop. He has emphasized that in the said Lok Adalat, no authorized officer of the petitioners was present, and the learned lawyer for the petitioners had made some concession beyond the instructions. Full stop. He has otherwise submitted that in absence of the parties, comma, the entire essence and objective of the act would be defeated, and accordingly, the said settlement is liable to be interfered with. Per contrast, the Hawk, the learned counsel for the respondent number 1, has submitted that though it is a fact that none of the officers of the petitioners were present on the date of the Lok Adalat, comma, the learned lawyer for the petitioners was equipped with appropriate instructions, and such instructions were also in the form of WhatsApp messages, which were displayed before in the proceeding. Full stop. He has also submitted that in the affidavit filed by the petitioners in the proceedings, comma,
MA lordship.
huh?
MA lordship. MA that term. Not
MA
AP.
means?
Miscellaneous application lordship.
In the miscellaneous application, comma, the liability was admitted, and therefore there is otherwise also no illegality in the order passed on 14/9/2024. Para? Without going into the inter se merits of the parties who are in dispute before the learned commission, comma, this court is of the view that under the Act of 1987, a settlement can be arrived at between the parties in the Lok Adalat, and such settlement are final in nature. The objective of the Act is to bring disputes to a final settlement for which the presence of the parties and their consent and their free consent is mandatory. Full stop. Para. This court has also carefully gone through the records which were requisitioned by this court wide order dated 11/12/2025 on the specific issue as to whether any authority was given to the learned lawyer to act and sign the compromise. For ready reference, the relevant observations made by this court in the order dated 11/12/2025 are extracted herein below. There are 4, 11/12. On a careful examination of the records of the learned commission, this court has not come across any such authority letter. Full stop. Para. In any case, the requirement of the Act is for arriving at a settlement by the parties, which implicitly requires the presence of the parties. Full stop. In the instant case, the petitioner being a company, it would be their authorized representative. It would be the representative who is duly authorized to enter into such settlement, which apparently does not appear to be done in the instant case. Para. In view of the aforesaid direction, this court has no other alternative but to interfere with the order passed on 14/9/2024 in FA 76 of 2018, which is accordingly done. Full stop. The FA is required to be considered and disposed of by the Commission on its own merits. Full stop. It is further observed that since the appeal is pending since 2018, expeditious steps be taken by the Learned Commission. No, expeditious steps be taken by the Learned Commission for expeditious disposal of the appeal in accordance with law. The records be sent back forthwith. ये भी चाहिए ना, इसको कुछ कोट कर देंगे. Madam, your name is there. Why aren't you present?
I was in another court matter, sorry.
You need to be invited to this court,
Sorry, ma'am.
specially. You be ensure that somebody should be there. Yes, what is it?
My lord, here, my lord, an NIT was issued in terms of order annexure B, my lord. Annexure B, there is an order in terms of this order. This order was issued by complying with the my lord, direction given by the Honorable Supreme Court, my lord. So in terms of this, NIT was issued and the petitioner submitted his tender by fulfilling all the required criteria, my lord. That's on 14/7/2025, my lord, annexure at page 30, my lord. Annexure E1. And all the testimonials I have annexed, my lord. Yes, and he is the highest bidder.
Yes. What do you say, madam? Her case is that in the NIT certain clauses should have been there which are not there. So you are diluting the requirement. What do you say?
No, but in this case, my petitioner arranges my order of 10/12/2025, my lord. Page 37, my lord.
Yes.
My lord, this order has been passed by following the Supreme Court direction, my lord.
Earlier one
There is
also,
nothing wrong in this order, my lord.
What is the error in this order? Illegality in this order?
they are contemplating to cancel the earlier, my lord, NIT and issue a fresh, my lord.
No, this is
tender.
in accordance with the Supreme Court direction.
Earlier was also, my lord, the same clauses were there.
Now,
my
what
lord.
prejudice will you suffer?
My lord, the petitioner has submitted all the documents and he
No, you can
is
submit.
the highest bidder, my lord. And this is, they are repeating the same thing, my lord.
Where is the,
Earlier also-
where is that document that you have been adjudged and emerged as the highest bidder?
My lord, highest bidder, my lord, I have not annexed the document because the document is not available.
Then how do you know that you are the highest bidder?
My lord,
Has any
I
right,
can say, my lord,
has any right fructified in your favor? Has any right been vested in your favor in the earlier tender process?
No, my lord.
Then you are simply an aspirant.
Repeating, my lord, earlier also that order was issued in terms of the same clauses are
Let
there.
us see earlier
Annexure B, my lord.
page.
Page 21, my lord.
Madam,
Where-
we
where
can
are
examine at
45?
best, you can examine at best, but you participate in the new tender. If you are successful, then we can.
Yes, my lord.
Okay.
That will be done.
Third, Miss S.B. Chaudhary, learned counsel for the petitioner. Full stop. As per the facts projected, comma, the petitioner had participated in a tender process for settlement of what?
Of Kakra Nodi fishery.
Where do you say?
My lord, page 30, my lord.
Of. Where is the name of
And
the?
NIT, my lord, is that page, my lord. Annexure D, my lord.
Of Kakra Nadi in the district of Sribhumi
Yes, my lord.
and claims to have been adjudged as the highest bidder. Full stop. However, without bringing the said process of settlement to a logical conclusion, the impugned notice has been issued on 10/12/2025 for settlement of the for settlement of the fishery in question. Full stop. Para. Ms. S. Chutia, the learned standing counsel Fisheries Department, has however contended that the fresh notice dated 10/12/2025 had to be issued in incorporating the guidelines and directions of the Honorable Supreme Court, and there is no illegality in the same. Para. Let notice be issued, returnable on 4th of February 2026. Ms. Chutia, the London Standing Council accepts notice on behalf of all the respondents.
1, 2, 3.
1, 2, and 3. District Commissioner, you thus State Council for 4 extra copies. Para. Ms. Chaudhary, the learned counsel, prays for an interim order. Para. After considering, comma, this court is not inclined to pass any blanket order of stay. Full stop. It has, however, provided that participation of the petitioner in the impugned tender process would be without prejudice to her rights, which don't say her, to the claims which have been made in this petition. Furnish extra copies, madam.
Yes.
Article 3.
Well, sir, I applied for respondent number 2 on behalf of Mr. Tina. We need 1 week time, I also, to file our reply.
You have not filed your reply.
No, not
Okay.
filing, just recently.
Okay, we'll give it 2 weeks. On a request made on behalf of Sri Deenath, learned counsel appearing for the respondent number 2, 2 weeks further time is granted to file affidavit in opposition. We fix a date.
Yes.
Yes, ma'am.
List on 30th of 30,
Of this month.
30 January
This month.
Item
2026. Item 4.
Well, this is, I guess, a banning order without
So far without hearing, my lord. Your lordship may just look at the last one.
Notice was issued, yes, affidavit filed.
Lordship, I am representing only respondent of one lordship, 2 and 3 are the
Lane
lordship.
2 and 3, my lord.
Who are 2 and 3?
20
Sir,
Silsor
yeah,
NIT lordship.
Huh?
Silsor NIT lordship.
NIT seems, sir.
Served or not?
Sub. We have submitted by the affidavit also.
Dusty
Trustee,
affidavit.
we have submitted affidavit. Yes, sir, madam. Your lordship will just see the last of them.
Lordship may posted any other day, in the meantime they will appeal. lordship.
Normally who appears for Silchar
Normally,
NIT?
lordship,
SP Kyle or SP Chaudhary?
SB Sodhi.
SP Chaudhary.
SB Sodhi. I will inform him lordship.
I think Mr. Chaudhary appears normally.
But here, my lord, your lordship may, my lord, see, my lord, that the interim, in that case, interim order to ask, court wanted to dispose of the matter.
No,
today.
that we have understood. We'll give another chance, okay?
Only,
Uh,
only
Lord-
interim order will be passed, my lord, today. Your lordship may see, my lord, no so-called, no hearing, nothing, my lord. I can test, my lord, teach of judgment, my lord.
Try to get Mr. Chaudhary, SP Chaudhary.
Lordship.
After a while, you can have your
Fine.
associate also in the court.
My lord.
Lordship.
You need not be present, Mr. Sayola.
My lord, I shall come.
We'll record your name.
Yes.
Item? Yes.
Yeah, I have been requested by my friend, Dr. to appear before this court. Award is at page 53.
You are the workman.
No, I'm
You are the
the,
management.
Yeah.
4428.
the long award, you know, precisely precise case before you observe lengthy, long word.
Award is for what? Reinstatement?
Yes, reinstatement like languages.
In a reference or 2A?
No, in the reference.
10 reference.
Hmm.
Okay.
Yes, the reference.
Can we come to the award? You want to us to read the award or what? You want this court to read this award or you'd like
No,
to place
no,
the facts?
the lengthy, the
Which
about
page? Which page?
20, 53 to 79 page.
What is the date of the award?
Award is date of the 2019.
31?
2019.
Award. By whom?
By the Labor Court Assam at Dibrugarh.
Dibrugarh. Okay. Yes.
The precise case is that the delinquent workman was the head clerk of a tea garden. Now,
Yes.
he was called upon to collect rupees 30 from each worker for using the electricity in the garden.
Yes.
Now, he had collected that
Yes.
amount, but he had not deposited the same. Now, according to the delinquent,
Yes.
according to the delinquent below, that though he was instructed to collect the amount from each worker who were consuming electricity of the tea garden, but the general manager had not given any instruction to deposit the same.
Hmm.
As a result, what he wanted to say that though he had collected the amount, but he has not deposited it, but he kept in record by a kacha book. What he in a written, but he had not deposited the amount. Now, when it came to the notice of the management, Lord, he was called upon to their office at Dibrugarh. He went there and that was the date of 13th of August of some year, my lord. On that date, my lord, he locked his office and he went to the Dibrugarh. But as the office was locked, some manager and with some other union official broken the lock and taken the records. Thereafter, my lord, he was placed under suspension. Now he had submitted his reply. In that reply, he had admitted his guilt. Not guilt, he has admitted the situation. Yes, I have been instructed to collect it, but as there was no such relevant instruction to deposit it, so I had not deposited the same, but I kept the money with me and I kept some record with them. No, inquiry officer was appointed, and in this inquiry, he was found guilty, and thereafter, my lord, he was terminated from the service. Now, my lord, what it revealed from me, in the written proceeding, management has not prayed for examination of the fairness of the inquiry.
Firestone. Firestone.
He has not. So, as a result, the inquiry, they have relied on the merit as well as the domestic inquiry. Now, what I found, my lord, according to the presiding officer, the inquiry is not fair. So what he found that the person concerned who issued the charge sheet, he adduced evidence and he also dismissed the delinquent workmen, and probably probably for that ground he declared that the inquiry is not fair. But inquiry is not fair.
No, issuing the charge sheet and dismissal, that is not, cannot be illegal, but he could not have adduced evidence.
Yes, we could. So what I found somewhere here, that he issued the charge sheet, he dismissed the workman, he appointed the inquiry officer, all these grounds were taken, so he was of the view that the inquiry is not fair. Now, because of the fact that the inquiry is not fair, he cannot be automatically reinstated, because there is an evidence on merit. So, if we go through the Lutbushing's case, there are some parameters have been laid down. One is that the management can, I would not like to refer it later if required. Management can adduce evidence.
Evidence in this tribunal or labor court.
Hmm?
Management can adduce evidence first before the labor court.
Yes, medical evidence, without taking any plea that he will rely upon the inquiry as a preliminary issues. So if it is found the inquiry is unfair, then the management, then and only then the labor court will examine on material on the record, on the basis of the material on record. For the labor court or industry or tribunal should come to a conclusion that inquiry is not fair. And if he is of this view, then he will examine the matter on merit.
Merits.
Now, here that has not been done. That is one of the aspects here. Yeah. Let's straightway. So, for the merit is concerned, I have some better case. Now, page 76, minute. Both the parties adduce evidence on merit also. Management examined 3 witnesses, 5 witnesses, 6, no? Oh, 6 witnesses. Now, paragraph number 41, on perusal of the evidence of the management side, it appears that the general manager, Lord Noshik Bhatt,
Yes.
that the general manager MW1 informed MQ2, M3, M4, and M5 about the proposal of increasing electrical charge from the residential staff. Then they replied that they have already paid rupees 30 per month from their salary, which has been collected by the workmen. Then MW1 told them to lodge a complaint before him regarding the matter. And accordingly, Rajwar MW2, Madan Kurmi MW3, Cheniram Kurmi MW4, and Tankeshwar Tanti MW5 and others submitted the complaint before him. Exhibit B. That means the MW1 did not get any complaint regarding the collection and non-depositing of rupees 30 as a as electrical charges, but he himself invited that the complaint from the aforesaid witnesses and others. Thus, it cannot be ruled out that MW1 has some biasness against the workmen, as he initiated the process of all faculties in order to give trouble the workmen in his service. There is no evidence on record about the previous bad antecedents of the workmen. It is also noticed that MW1, being the authority of the garden, issued show cause notice as well as the charge sheet, appointed the inquiry officer, become one of the witnesses in the disciplinary proceedings, also accepted the inquiry report and passed the order of dismissal of punishment against the workmen. As such, the whole process of inquiry and thereafter the order of punishment inflicted upon the workmen is vitiated. It has been held in Muhammad Yunus Khan versus State of UP 2011-1 LS page number 180 CA number such and such paragraph, that the authority who initiated the disciplinary proceeding against the appellant become witness before the inquiry officer appointed by him, who is subordinate to him in his office, and also accepted the inquiry report and passed the order of punishment. Thus, the order of punishment should be vitiated. Well, that is a service case probably. I have found the evidence in record and also written statement of the workman, paragraph 42, written statement of the workman who has admitted the collection of rupees 30. There is an admitted position from the residential staff as electrical charge per month as per instruction of the then manager of the tea state, Mr. R. M. Patnaik and M. Upadhyay. He also admitted that he had collected about 24,000 to 25,000 in total from the staff as electricity charge. He also admitted that he maintained a Kacha book wherein he made entries in relating to the collection of the electricity charge from the staff. Under these facts and circumstances in this regard, though the workmen admitted about collection of electrical charges as stated above and also maintaining records in a Kacha book which is kept in his office, but he was unable to produce those records. Well, that is the only case. He maintained Kacha book. These Kacha books were taken away by the staff of the manager, and he could not produce the same before the inquiry officer. Produce those records ordered to place before the inquiry officer as well as before this court for this case, because of the management put a new lock after breaking the original old lock of his office chamber by the management, thereby preventing him to enter in the office to collect the Kacha register. Only please that he maintained a Kacha register, but that Kacha register was taken away from his office, and thereby he was deprived of to produce that document before the inquiry officer as well as the court. Into Kacha register, as a result, it is a clear case of denial of opportunity for defending the case of the workman. Moreover, after breaking the old lock, the management has not brought any charge of misappropriation of those collected amounts against the workmen. as per the evidence of some of the management witnesses on record, that the workman used to maintain a separate register wherein he recorded the entries of the collected amount. It is evident that the management broke the law of the office wherein the workman used to keep all his payments related register of the garden. But it is not known whether the management brought all the register from that office of the workmen or not, and they put a new law in that office. As a result, the workman was unable to collect any documents regarding collection of the electrical charges. In fact, neither the management of the garden nor the workman has able to produce any kind of kacha register documents relating to recording the instructions of collecting the electrical charge before the inquiry officer and the court. Under the above facts and circumstances, I hold the dismissal of the workman from his service is unjustified, as he was not given any opportunity to defend his case during the course of domestic inquiry, which is a clear violation of the principles of natural justice. The issue number 1 is decided accordingly. Now, issue number 2. Because he was what has been discussed, 78 page number 78. What has been discussed in issue number 1, the workman is entitled to get reinstatement. What has been discussed in issue number 1, the workman is entitled to get reinstatement in his original post. As per the evidence on record, it appears to me that the workman might have been retired on superannuation. So there is no question of reinstatement in his original post. Consequently, it would be justified to hold that the workman is in service from the date of suspension from the service till the date of his retirement on superannuation, shall be treated as he is in continuous in service in the said post. Considering all aspects, the workman is entitled to get all his service benefits and back wages from the date of his from suspension. Issue number 3 and 4, it is that is not very relevant. There is a date of birth. It is found that the issue number 3 and issue number 4 of the reference is framed by the government of Assam, were neither raised by the workmen union nor by the management of the garden during the conciliation proceeding held on 8/11/16 and 29/3/2016.
These issues have been declined to be discussed, not required.
Does not require. This is my simple case, Miguel.
Okay. There is no scope of reconciliation.
That can be done. I don't
Why
know.
don't you settle and reconcile? Why are you fighting? Ultimately, the question of reinstatement is not there. He has surpassed the age of superannuation. It's only a question of monetary benefits, which you are aggrieved. Madam is there, you can sit and settle.
I will instruct Mr. Datto to do this.
Madam,
That may be done.
see, we have not
Because your-
expressed any opinion on the merits. Mr. Dasgupta may have a good case. But it also appears that MW1, who had issued the charge sheet and also the dismissal order, he was also a witness in the proceeding, which is not legally permissible.
Yes, yes.
That was in the domestic inquiry. Mr. Dasgupta is trying to make out a case that even if the domestic inquiry is
Unfair.
interfered with, but the fact that the order of dismissal was arrived at on the basis of witness given by the authority, that will still remain. That
Yes.
that will is a difficult hurdle for you to overcome.
Hmm.
That's a matter of fact.
Hmm. So the Ludbur Singh's case covers this.
No, Ludbud would cover. Ludbud is on the fairness of the domestic inquiry. If not, then you are entitled to give evidence on merits in the labor court or tribunal.
No, as well as simultaneously we can adduce evidence on inquiry and merit.
Merit, yes,
Yes.
that is it, merits. On the merits,
Simultaneously.
but Mr. Dasgupta, ultimately, your endeavor is to justify the termination order, the dismissal order,
Hmm.
which was arrived at on the basis of the evidence led by the authority.
Yes.
That
That
hurdle,
was not discussed.
that hurdle will be a difficult hurdle.
Yes.
If
So
that was not there, then perhaps you could
That-
have argued. That is a matter of fact, it is on record.
And my lord, here what happens, my lord, on 2/9/2000.
So without even going into those aspects, without expressing any opinion on merits, why don't you sit and we can have a conciliation, we can have a mediation here in this court. If you want, it can be in Dibrugarh. But of course, Mr. Dasgupta would like to have instructions through his associate,
Shishir Datta.
Mr. Datta.
And otherwise also, my lord, there is no fault of the workman, my lord, because that instruction, my lord, to deduct electricity, it was.
No, Madam Bhattacharya, we are not
Without
even
going
going,
into
we are
merit.
not even
I
touching the
understand.
merits.
Merit, if you go
We are
back,
not touching
it
into
will
the
be-
merits. We are not touching the merits.
will
We are
be
on a
trouble.
very technical issue,
I-
which is also important. When can we have? Mr. Ratta will be available tomorrow.
No, today itself, he will be video conference. The Itanagar bench, he is at Guwahati, Milord. He is in Guwahati. He told me to ask you this case.
No, we can have it in his presence. You can instruct him to convey this part.
Hmm.
We can have this when? Immediately on the reopening?
All right, no
that-
problem.
that-
Or your
I think
lordship can pass an order.
19th we are reopening, isn't it? 19th, after the Bihu vacation. We can have it on 20.
Datta, I can call Datta in this court, Milord. At 2, your lordship can pass an order.
Is he there in Guwahati?
Yes, he is in Guwahati.
Who is in
He is in
Guwahati?
Guwahati, he is conducting a case with the Arunachal
Okay,
bench.
video conferencing from here. Okay,
Yeah,
then
yeah,
we
yeah.
can have it at after a while.
After.
A while. But in a short time, you're so well prepared. What is the secret? By the time he's in video conference, you're fully prepared with the case.
Ah.
You should tell us the secret. Okay, after a while.
No.
See, 2 o'clock, we may have some difficulty in sitting. There is some other for the upcoming program, so we'll try to have it.
Lordship can pass an order, I will convey to him.
No,
For
let it be done in his presence. He should not be in difficulty. All of this. Madam, in the meantime, you can also have a word with your client.
Yes, I will take instruction from my clients.
Of course, mediation is without prejudice to your all your rights. If you fail, you can still we can still adjudicate this issue.
Lordship, in respect of item number 7, Lordship, we have received the pair-wise comment of the affidavit. So Lordship may give some time, we will file
These
affidavit.
are connected.
Connected matter and other 2 matters.
Mr. Sahu are appearing in all the cases.
Yes,
All the cases.
What is the issue?
issue relating to non-payment of subsidy of the tea by the tea board to the tea estate.
Non-payment of subsidy of?
Tea subsidies for the replacement of the tea plantation.
You are entitled to certain subsidies,
Subsidy.
which they are not paying.
Yeah.
Yes, what do you say?
Lordship, as per our stand, Lordship, he is not entitled, Lordship. Some part he has already, Lordship, he has given, Lordship.
Mr. Chaudhary, you appear for whom? Some of the cases. Yes. Okay, same stand.
Not the case that they have received subsidies. They have received subsidies, but. in the
You
instance-
say that whatever they are entitled to, they have received,
Already received.
and they are asking for something which they are not entitled to.
Something that-
Okay, but these are all different. Is it the same industry? No.
No, different tea estates.
So you need to file separate affidavit.
Lordship.
Yes.
Lordship.
You file affidavit then, but 23 matter,
Lordship.
With,
In others matters, affidavit is already filed, Lordship.
which one you are filing?
Only item number 7, Lordship.
7.
Only item number.
These are connected. Do you file in 7 also? Will you like to file any rejoinder to the affidavit?
We have already filed and that I will file other
Okay,
space.
okay.
Lordship, other restrictions also there, Lordship. 710 is not take with this matter.
Okay,
That
okay.
matter.
Heard. 3D Sahu, learned counsel for the
Seven.
petitioners in these cases. Also heard Sri RKD Chaudhary, learned deputy HGI, and Sri K. Gogoi, learned CGC,
Lordship.
who appears for the respondents. Full stop. It transpires that except for WPC 148 of 2024, in the other cases, pleadings have been exchanged.
Lordship.
Full stop. Sri Gogoi, the learned CGC, prays for some time to enable filing of affidavit in opposition in the aforesaid WPC 7 on so and so, for which he seeks for, full stop. He has also submitted that there is another writ petition which is connected
Lordship.
and not listed, being WPC
WBC Lordship 710 of 24.
710 of 24. Pleadings complete there,
Complete Lordship.
in which pleadings are also complete.
Lordship.
Para? Any of the above, consideration of these matters stands deferred to
Only after 3 weeks. Lordship. Yeah, keep service.
6th of February or around?
Lordship,
Yes,
Lordship,
to
Lordship.
6th of February 2026, by which time further pleadings may be exchanged.
Lordship, Lordship, Lordship.
List along with WPC protocol, no?
710. Oblige, Lordship.
Is there any interim or no interim?
No, Lordship.
No,
Oblige, Lordship.
Okay.
Lordship, in respect of item number 4, Lordship, we have contacted and my senior also, Lordship. My
Oh,
senior.
SP Chaudhary. Yes, NIT.
NIT. Lordship, may tomorrow or Lordship reopening Lordship.
On the rear, where is Mrs. Sahola's associate? Madam?
Lovely, man. Lovely, man. Sahela by the instruction of.
Hartsfield G and Sahola Learned Senior Counsel for the petitioner, as well as Sri K. Gogoi, Learned CGC. Full stop. The dispute, however, appears to be against the NIT Silchar.
Lordship, Lordship.
Full stop. The Learned Senior Counsel has drawn the attention of this court to the affidavit filed in support of the Dusty Service. Full stop. It appears that full stop. Since the contesting respond number 2 is yet to appear, in the interest of justice, consideration of this matter is deferred to on the reopening, okay?
Lordship.
On 19th.
Lordship.
19th. Please inform.
Lordship, I
Mr.
will.
Chaudhary, okay?
Lordship, that's one 2 and 3, Lordship.
2 and 3.
2 and 3, Lordship.
2 and 3, huh? 2
Okay.
and 3. 19th.
Lordship. Oblige, Lordship.
So this is also an error. Lordship may fix immediately after vacating. It will take some time. At least 1 hour time will be taken, minimum.
We had more than 1 hour today.
No, more than one. It will be fixed on 12.
We do not have any other case. Okay, if you are uncomfortable, have it on after the vacation.
Immediately after vacation.
Okay, Mr.
Otherwise,
Chakraborty.
it will not be possible.
Heard.
Your lordship does not that too.
Heard Sri Ida
I am
Learned
prepared.
Senior Counsel for the petitioner. Also heard Sri S. Chakraborty Learned Counsel for the
Walkman.
sole respondent workman. Para, on the request of Mr. Dasgupta, consideration of this matter is deferred and the same is directed to be listed for hearing on
20th is the hearing day, 20.
20 we have many cases fixed. We have it on 3rd of February. Is it okay? Tuesday. 3rd February.
আমার আজকেও করতে পারেন হবে না সম্ভব হবে না
What time be?
Dotto still is in the video conference.
Okay. Madam Bhattacharjee, where is she? Can you please request them to
The chamber.
come to my chamber? We can
The
pass
chamber.
orders. Okay.
All right, all right. I will instruct him.
Need to ratify this. Is the process.
Hey, that's that.